is a part-heard appeal in the matter of Lufthansa Technik AG and Astronics Advanced Electronic Systems.
Yeah, the heat wave is due to last for several days, so within the bounds of decency, everybody can wear exactly what they like.
Very grateful for that, Arnold. At the end of yesterday, we were discussing the economic logic of the position regarding safety and regulatory factors in the context of remoteness and the judge's finding on legal causation. And I was explaining my position that these allowed participation in the market, that they were not in and of themselves profit drivers. Compliance does not bestow any competitive advantage. That is the default position, and it applies when there is no technical difficulty in achieving compliance. But to be clear, technical difficulties can and do make a difference if it's very hard indeed to engineer a toughened windscreen glass, and you conceive of a method which does it quickly and cheaply. That will give you a competitive advantage. Or there may be a technical difficulty which might exclude some market participants altogether because they couldn't solve the challenge. In the present case, Lufthansa achieved compliance with the safety requirements for a mains voltage passenger power supply. They obtained a patent for their particular solution, and that validly excluded third parties from using that same solution. And Astronics were unable to conceive of an alternative solution. So in those particular circumstances, as against Astronics, the patent was an utterly dominant profit driver. It was exclusively determinative of Astronics' ability to enter the market at all. And there was before the judge no pleaded case and no evidence which asserted any equivalent or even similar difficulty in relation to other safety or regulatory features. And as we shall see now, when we return to the judgment, the judge didn't rely on any. The judge goes into great detail about the background to the regulations, and this starts, so we're back in the confidential bundle, page 208. There's a long section beginning above paragraph 356. What was the scope of the invention and what was its relevance? And if I could take you forward to 361, please. The judge says this: but whether the inventive core of the patent was the insertion test or a combination of the insertion test and the remoteness test, or indeed a combination of all three features, I'm not satisfied that this answers the question whether the patent was a gateway or barrier patent. My lords, again, for the reasons we discussed yesterday, that reasoning simply isn't open to the judge. Once he found, as he did at paragraph 3 or 4, that Astronics had no non-infringing route to market. You don't need 2, 3, 4 barriers. One will do. We'd established it. And then he continues, if the defendants could not obtain certification without infringing the patent, it should make no difference that the regulatory authorities or the airlines focused exclusively or predominantly on the insertion test. The patent was still a barrier to entry into the market. Pausing there, we say the certification question is irrelevant once the NIA case failed. But the regulations worked as a squeeze on Astronics. They were a critical element of the architecture of the NIA argument. The regulations prevented Astronics from saying, we could have just installed a domestic outlet like you got on the desk in front of you. That's a non-infringing alternative. but it wouldn't pass certification. So the challenge for them, the Scylla and Charybdis, were on the one hand the patent, and on the other hand, the regulatory environment. That was where the regulatory environment came in, and they failed that challenge. And they failed the NIA test. It was spent by that stage. The judge seems to think it's still relevant to causation, but we say it's not. The causal potency of the patent was established at its absolute maximum. You can't do better than a complete barrier to the market. Back in that same paragraph in the judgment, on the other hand, if the defendants only had to find a way around the insertion test and not the remoteness test, then this weakens the causative strength or effect of the infringement. Again, we don't understand what's going on here. There's no warrant for getting into the integers of the claim. The dealings were established as infringing, and there was no route to market any other way. So the correct analysis is much simpler than this. They had no route to market, unable to find a way around the requirements of the claim. As a result, it simply didn't matter whether they could achieve certification or not. The barrier status of the patent was established. As to the safety features, could we turn forward, please, to paragraph 369? The judge records here that Mr. Duper gave evidence about other technical and safety requirements, and that's right, he did. And at the end of 369, the judge says that he finds that the patent provided the answer to one single safety requirement, and that Astronics had to satisfy a further 24 conditions in order to obtain certification. Well, to the extent that they were pleaded at all, and it wasn't in relation to causation, this is the warning labels and the on-off switches again. Professor Weeder said they were all trite, unchallenged. Mr. Duper did not say that there was any technical difficulty in complying with any of these other requirements, and the judge is not making any findings to that end. And there was no evidence that suggested the airlines or the IFE providers preferred Astronics because it had met these requirements. Everybody did. The next paragraph, please. The judge refers to the IPC media case. That was a case about copyright infringement by excision, where Mr. Justice Laddie quoted a line attributed to Michelangelo: "I saw the angel in the marble and I carved until I set him free." And the judge has taken that to be a reference to, or to justify a reference to the other hurdles which any manufacturer would have to come to achieve certification.
Your essential point is that if you've got 25 criteria in order to get certification, and you satisfy 24 of them independently of the patent, you don't get certified. You need the patent to satisfy the 25th criteria.
Not quite my point. My point is, if 24 of the criteria, well, firstly I say that none of this matters to the patent status, because that's got its gold award already. You know, the NIA case resolves all of that. You cannot have a stronger causative relationship. Put that aside. What's the relevance of these other matters? If the evidence was, look, yes, you have to, come up with a safety system like this, but you also had to solve a really difficult question about getting this to work at low pressure, or some other issue about being on an aircraft. And we worked really hard at that. We're the only people who managed that, and that needs to be acknowledged in this arena. That at least would be an argument that made logical and economic sense. But that wasn't the argument. There was nothing to raise these other features above the level of a warning label. the evidence was they were trite. And what the judge has done is, merely because there were other requirements, he sort of equates the gold standard patent barrier to the market with these other requirements, like a counting exercise. We said there's a very good reason none of this was pleaded on causation. It's utterly irrelevant to causation. Quite why the judge has adopted it as a profit driver is, to us, inexplicable and unjustifiable. And you see it in paragraph 370 when he refers to hurdles. Now, we've got the hurdle that's the patent. It's the highest hurdle that one can jump, too high for Astronics. And then we've got other hurdles. Well, let it be that there are other hurdles. You've got to put a warning label on and an on-off switch. How much of an impediment is that in the market? How is that distorting competition? They're not hurdles at all. If you wanted to set them up as hurdles, fine, you could plead that and you could lead evidence, but none of that happened. These were bureaucratic requirements, like putting on a sell-by date on your bananas. It's not a hurdle. It's not a profit driver in itself. Now, at the end of that, 370, having said there are all these other factors, he says that he's going to have to evaluate them. And at that stage, you think, well, okay, so he's just putting off. At this stage, he's simply counting them, and there are 24 other ones, and he's going to come on to evaluate them and say, he's going to deal with Mr. Cuddigan's arguments and Professor Wheeler's evidence that they're all trite. But he never does. If you turn forward to 467, you'll see how instead this is all dealt with in the conclusions on the notes. The judge has 9 reasons.
Sorry, 467. Yes.
467, page 2561.
Yep.
The judge has 9 reasons why the infringement was not the legal or proximate cause of the profits in issue. The first one comes in 2 parts. It says that the 1999 memorandum was not introduced to require use of the features of the patent. We say that was of no significance once the NIA claim failed. Second part, he says the mating condition was one of 24 safety conditions which Astronics had to satisfy. Well, so be it. But the technical evidence was that the previous safety features were trite. Nothing to indicate any of these requirements involved any technical difficulty, and there's no reasoning in the judgment to the contrary. Nothing to raise them above tire tread depth and toughened windscreens. The mere presence of a requirement to have a warning label is of 0 causal significance. Then number 2, the judge records that the patented safety features were used to get approval from Boeing and Airbus, but there were 36 additional safety tests which were needed. Again, so be it. But to the extent that they were pleaded at all, the unchallenged evidence was they were trite. They were not said to be anything to do with customer purchasing decisions, which is why they were pleaded in a different part of the points of defence, and there was no basis for any conclusion of market significance. At 3, the judge divides claim 1 of the patent into 2 features and says that they were necessary but not sufficient. He says that compliance with all the applicable safety requirements and technical specifications was the real driver of the sales in issue. Without any supporting reasoning or any evidence, or indeed a pleading, he is elevating features which are common to the market to the rank of profit drivers, the same relevance as the patent. There is no procedural, logical, or evidential warrant for that approach. At the end of that paragraph, the judge refers to NEO, and that reference we say is important. As we saw when we looked at NEO, the real driver language was used in the context of a performance requirement. Car makers wanted catalysts which performed well as catalysts, and the cerium oxide was only one ingredient which contributed to that performance. My lords, product performance is a paradigm profit driver, just like price or, on an aircraft, weight. In NEO, good performance meant the difference between sales and no sales. If these features referred to here by the judge were said to make for a lighter, cheaper, or higher performance passenger power supply, then his reasoning would not be objectionable. But none of those characteristics apply, none of them was ever said to apply, because these were just regulatory requirements. There is no justification for treating them as if they involve valuable inventions, which is what the judge has done. My lord, I come on then to our fifth and final error in relation to legal causation. This is short but significant. Recall that we are only dealing with Astronics and not Panasonic at this stage. The way the judgment is structured is that the judge first decides in favour of Astronics on legal causation and then says the same decision applies to Panasonic. Could you turn please to paragraph 417 on page 240. Bad reference. Yes, 242. So this is the judge's section on the facts about why Astronics outsold KID. And here he accepts Mr. Brady's evidence. The percentage of power-only sales, which Astronics made, was only 22% of its overall sales. The remaining 78% in sales to IFE, in-flight entertainment providers. The judge's point here is that sales to the IFE providers dominate the market. But these figures of 22% and 78% relate to global sales. And outside the UK, Astronics supplied IFE companies like Panasonic and like Thales. The accounts before him was only concerned with infringing acts, supplies within the UK. As to those, Astronics UK supplies were 100% power only. So the correct figure for this issue was 0% IFE, 100% power only. And if you move forward then to the judge's conclusions back in 467, this is page 262. At subparagraph 5, he relies on the market split between power only and IFE sales. He says that providing AC power was not commercially essential to the IFE sales. Well, even if that was correct, since no IFE sales were an issue for Astronics, the commercial drivers for those sales were irrelevant to the legal causation question he was addressing. The court's task was to determine whether the profits on Astronics UK power-only sales were legally caused by the infringing acts of supply, and this reasoning was of no application to that task.
So the corollary would be that Lufthansa are not entitled to any part of the profit made on supplies to IFE providers outside the UK.
But we never claimed any profits. They weren't UK infringing acts. There's claims in Germany and France in relation to German and French infringing acts, but in these proceedings, there's no extra jurisdictional claim for infringement. Just to be clear, it's our position, there is the respondent's notice on it from our learned friends, but this is of no application to Panasonic either, because Panasonic offered a suite of products. You could choose your power supply. AC power was the most expensive, and it was the heaviest. So there's a double penalty for choosing it, which is why the evidence confirmed that it was only installed when it was a non-negotiable for end users. That's effectively the business class users who wanted to plug their laptops in. To put it in Abbott terms, for those customers, the airlines insisted on infringing inserts. So the point was bad in any event. My lords, that's the end of my ground three submissions. There were 2 points I thought it might be helpful to come back to from yesterday. First, there was a question that my Lord Justice Nugee raised about 2 routes to a development site. My Lord asked the question in the context of user damages, but I wondered if it might be helpful because we're concerned with differential profits and but-for causation if I gave an answer by reference to conventional subjective damages. So there are 2 parcels of land, A and B.
Sorry, did you say subjective damages?
Yes, well, I subjective as in damage actually sustained by the
That's a terminology I've never ever heard before.
Right.
So hence I'm baffled by
Yes.
your use of the word
So
conventional.
it's to distinguish objective user damages. Here's your market compensation. It is compensation for the damage that you actually sustained. That was my shorthand. So that's what I mean. So real losses, not negotiating damages. So 2 parcels of land, A and B, both providing access to a development site. I think that's what my lord put to me. And the developer used route A, and let's say in doing so, damages a valuable building on that site. And the owner of parcel A sues for trespass and claims compensation for the damage of the building. It has no impact on that claim for the developer to say, I could have used route B for nothing. That is a legitimate non-breach alternative, but in that alternative, the landowner suffers no loss. His building is undamaged, so there is no deduction. It's the precise converse of the Rupadza position, where in the correct counterfactual, the defendants accrued no profit. So there's nothing to be deducted. It is only where in the non-breach counterfactual, there is the same or similar financial outcome to the real world breach that a deduction is made. And that is right and proper, because in that situation, the claimed loss or profit is not wholly caused by the breach. But the second point was an issue raised by my Lord Justice Arnold about the relationship between the claim and the act of infringement, and I just wanted to make our position absolutely clear. If we go back, please, to our skeleton for page 55. We looked at this paragraph yesterday. So we are concerned here with the relationship between the
Which
claim
paragraph,
convention.
Mr. Cardigan, which paragraph?
I'm so sorry. 79 and the little spreadsheet box up there.
Yes.
We're concerned with the relationship between the claimed invention and the transaction which is recorded here. As I mentioned yesterday, this quote was introduced by Astronics under the words proposal for the mPower 110 volt AC passenger in-seat power system. That is their characterization of what's being sold, and that is precisely what claim 1 of our patents covers. And that's why the judge at the first instance liability trial made the following declaration. The mPower in-seat power supply system is a product falling within claims 1 to 3 of the patent. Now, claim 1 is to a voltage supply apparatus. That is what this quote is for. Claim 1 requires a socket detector with a socket with a socket detector, and that is what is called OU, outlet unit, on this quote. And you'll see that's quite a big ticket item. Claim 1 requires a supply device, which is remote from the socket. That is the ISPS here in the first row. That's the most valuable of all the elements. Claim 1 also requires a signal line and a supply line between the ISPS and the outlet unit. That's the fourth row. CA, that stands for cable assembly, ISPS to OU. And the rest of Claim 1 requires an insertion test, which is a feature of this device. Now, can I invite you to look at the rest of the entries? We've dealt with all the costly items. What's left is an in-use light, a cable to the in-use light, a seat grounding wire, and a terminator cap. These are just sundries and fixing hardware. This is, in substance, a record for the sale of an in-seat power supply according to the invention. And the judge, in his judgment, does not rely on any disjunct between this transaction and Claim 1 of the patent. He was right not to do so. Lastly, for the reasons we explain in our written argument, even when there is a disjunct between the claim and the invention, it is our position that this is addressed by differential profits. Consider the position in this case where we had a subsidiary claim, which we didn't have. Imagine there's a subsidiary claim to an ISPS attached to an in-flight entertainment system. Panasonic's non-infringing alternative would be an IFE system without an AC power supply, different power supply, or none at all. And they could rely on the sales they would have achieved with such products as a deduction. And they could also assert, with real merit, that their IFE systems themselves were too remote from the sales of the power supplies to be recoverable. And we recognised that from the outset and never claimed any profits on IFE sales. And in this way, the law of causation, as we have set it out, is apt to deal with all the problems that have arisen in this case. In other words, unless I can help you further, that was grounds 1 to 3, and my learned friend Mr. Hall was going to address you on ground 4.
Right, thank you.
My lords, ground 4 is Lufthansa's alternative position, in which we address the judge's approach to apportionment. Our primary position, of course, as my learned leader has set out, is that the judge shouldn't have gone that far at all. But in the event your lordships are against him on that, then our ground 4 arises. I'm going to make my submissions by reference to the position of Astronics, but the points I make apply equally to Panasonic. The judge's apportionment method led to him awarding Lufthansa 13% of Astronics' profits on the sales of primary components and 13% of its profits on the sales of secondary components. The method was based on the evidence of Astronics' expert accountant, Mr. Bazat, and he relied on a 2014 patent licensing agreement between Lufthansa and KID, which is called the 2014 teaming agreement. We say there are a number of problems with the approach, and they are the first and second points.
Sorry to interrupt. We're getting a message that Mr. Hall's microphone is not switched on, so it's not feeding through to the transcript writer.
That's something we can fix. I'm sure if it's not clear now, I'll be told. So yes, we say there are a number of problems with the patent licensing approach per se. That's our first and second points in our skeleton under this ground. At the same time as accepting Mr. Bazant's evidence, the judge disallowed Lufthansa's evidence from its expert accountant, Mr. Ryan. He had looked at another license between Lufthansa and Kidd. That's the 1998 teaming agreement. And he derived a figure of 84%. The judge disallowed his evidence on procedural grounds. We say he was wrong to do so, and that's our points 3 and 4. So I want to take them in the same order then that is in my skeleton. So the first point is the judge's use of the patent licensing agreement. My learned leader took your lordships to paragraph 573 of the judgment. That is where the judge refers to Lord Legate's judgment in Lifestyle Equities. The judge there cites the proposition derived from the Lifestyle Equities case that the purpose of an account of profits, and hence the purpose of an apportionment, is to put the infringer back in the same position financially as if no infringement has taken place. That's page 320 in the bundle. This part of the Lifestyle Equities decision is in the ratio section of Lord Legate's judgment. And the problem with an apportionment by reference to a patent licensing agreement, or indeed by reference to any intellectual property licensing agreement, is that it doesn't achieve that purpose. Because a patent licensing agreement involves the licensor and the licensee sharing the profit that is attributable to the patent. We address that submission in our skeleton at paragraph 107. And we do so by reference to a hypothetical product, but we can see the same problem if we look at real products. For example, the brassières in Peter Pan or the canisters in Dart and Dacor. Now those products, or those cases rather, are examples that my learned friends rely on in their skeleton. They say in those cases the intellectual property comprised essentially the whole of the product. And in those cases the infringer was ordered to disgorge 100% of its profits. Because, as my learned friends say, all of the profits can realistically be said to derive from the invention. That's their skeleton at paragraph 26. So I want to consider the hypothetical licensing arrangement that would be struck between the IP licensor and licensee in those cases. This is where 100% of the profit, or essentially 100% of the profit, is attributable to the use of the intellectual property. But a sensible commercial licensing agreement can't award all of that profit to the licensor, because then the licensee would be left with no incentive to enter into the license at all. So the incentive that it's given is, of course, a share of that 100%. Without that share, the license makes no commercial sense. What that means is that any commercially sensible agreement will allow the licensee to retain a share of the profit that is derived from the use of the intellectual property. And we say, as a matter of logic, that same result pertains to any IP licensing agreement, irrespective of whether there are other profit drivers involved as well as the intellectual property. Because in any license, the licensee's purpose in entering into it is to use the intellectual property in what would otherwise be an infringing trade in order to generate some additional profit. And that license is only of economic interest to the licensee if it gets to keep some of that profit. And this was precisely the economic evidence that was before the judge. And if I may, I'd like to invite you to look at that. It's in the confidential bundle, tab 8, page 455. This is Mr. Bazant's first report. I'm looking in paragraph 7.7, which is not confidential. 7.7. Page 455. Around about the top whole page, 6 lines down in paragraph 7.7, there's a sentence that begins, on this basis, the royalties in the teaming agreements can be used as a proxy for the share of profits attributable to the patent. On the basis that a license allocates via the royalty a share of the expected additional profits that arise from the use of the IP between the holder and user of the IP. And Mr. Besant confirmed that position in cross-examination, where he said that a license is the manifestation of the agreed profit split between the licensor and licensee. We cite that at paragraph 111 of our skeleton, and it may be worth just looking there. It's in the core bundle, tab 3, page 64.
Page, para 111
Paragraph
of your skeleton.
111.
That's what? Page 94 of the core bundle?
Page 64 of the bundle.
Sorry, I'm looking at the wrong skeleton.
Page 111. We cite there Mr. Besant's evidence. And the reason I wish to take your lordships to our skeleton is because there was also academic support for this proposition, which we see in the previous paragraph, 110. And that is an extract from the Patent Remedies in Complex Products textbook. Perhaps I could invite you to read that passage to yourself. So we say the normal commercial patent licensing agreement will allow the licensee to retain a share of the profit from what would otherwise be infringing activity, which means that an apportionment of profits on the basis of that normal patent licensing agreement will lead to the infringer retaining some of the profits derived from its act of infringement. That, of course, doesn't put the infringer back in the same position financially as if it hadn't done those acts of infringement. And so it doesn't achieve the purpose of the account of profits as stated by the Supreme Court in Lifestyle Equities. Now, we made these submissions to the judge. We cited Mr. Besant's evidence and the Complex Products textbook. And the judge's answer is at paragraph 598, which is 332 of the judge. See in the first line that the judge wrongly thought the submission only applied in a 100% case, like a Darting Decor or a Peter Pan case, where no apportionment was appropriate. What he failed to appreciate is that the point applies irrespective of whether it's a 100% case or not. Whatever the correct apportionment percentage is, analysing a commercial patent licensing agreement will always undervalue that figure. There wasn't any evidence that the 2014 teaming agreement was taking anything other than a normal commercial approach to licensing.
Does it follow from your submission that both Cipriani and Jack Wills were wrongly decided?
I'm going to address my lord on that in a moment, if I may. So we do say, therefore, that simply adopting the profit split derived, taking it straight out of the license, is inappropriate. And that's why we invited the judge to reject the approach altogether. We do say there is a possible alternative, which is to use the licensing agreement as a sort of a base idea, but then apply an uplift to reflect the fact that profits have been split between the parties.
Was there evidence as to what the normal commercial split between licensor and licensee is?
My lord, there was some evidence to that effect. both experts agreed that licensors tended to allocate between 25% and 50% of the profits from the patent to the licensor.
That's what I saw.
Yeah, we've cited that evidence in paragraph 114 of our skeleton.
So you could start with, if I've understood your argument correctly, you could start with the 13% figure in the teaming agreement, and you'd say that represents between 25 and 50% of the amount which, if 100% of the proper profit.
Right, so the 13% figure would amount to about a quarter to a half of the right number. So the right number would be more like 26 to 52% on that analysis.
If you take halfway between those figures, it would be 39.
I beg your pardon, my lord.
If you take halfway between those figures, it would be 39%.
Yes, yes.
So that's a fallback position, is it, of yours?
Yes, indeed, yes. But that's what I'm going to come on to address you on, is that that's just one data point. There are several others, for example, the 84% figure from Mr. Ryan, but that is one data point. 13% we say is too low, and it would need to go up to between 26 and 52%, when it's 39%. So that's the position on those licenses. On that license, I beg your pardon, 2014 teaming. In terms of Cipriani and Jack Wills, I have two answers to the submission. The first is the one that my Lord Justice Nugee has anticipated. If those cases endorse a bare licensing approach, as of the kind adopted by Mr. Justice Leach, then we say it follows they must have been wrongly decided, because that approach doesn't do what the Supreme Court tells us is necessary. But actually, the better analysis in my submission is that on the facts of those cases, neither in fact does endorse the judge's approach. And so we probably need to look at those two cases briefly. The first is the Cipriani case. That's in JA2, tab 37, page 844. And I'm picking it up at paragraph 18. What Mr. Justice Briggs, as he then was, is doing here is removing from the total profits profits which are associated with what he calls functional activities. That's the word in the line just above the first whole page. These are the things that are common to everybody in the market. And then we see the last sentence in paragraph 18. He then looks at the extra profit, which is caused by whatever intangibles are giving the service provider an edge. Paragraph 21, he finds that there are two such intangible causes of profits. One was the use of the claimant's name, and the other was the use of the third defendant's consultancy and management services. What he sought to do was to work out how much each of those profit drivers, how much each of those, how much of the profits overall were caused by each of those drivers. There were two royalty agreements before him. One was an agreement to use the name, and the royalty was 11.5%. And the other was a royalty agreement for the consultancy and services, and that was a 3% royalty. And the judge took the ratio of those two agreements, which led him to find that 79% of the profits were attributable to the use of the name, and 21% to the consultancy services. So we can see that the 79% figure represented all the profits attributable to the use of the IP. So when Mr. Justice Briggs applied that 79% figure to the defendant's profits, he was isolating all the profits attributable to the IP and awarding all of them to the claimant. And the infringer was left with nothing derived from the infringement. So that case doesn't provide support for the judge's approach, which splits those profits. The second case is the Jack Wills case. That's in the same bundle behind tab 48. And I can pick it up at paragraph 9 on page 1292. These are the findings that my Lord Justice Arnold made at the liability stage of this trial. And in particular, about 5 lines from the bottom, that the use of Jack Wills' trademark will have assisted House of Fraser to increase the attraction of its goods in circumstances where House of Fraser didn't undertake any advertising or promotion. So the conclusion is the use of Jack Wills' logo will have conferred a benefit, and an unfair benefit, upon House of Fraser. And then we can look at the position on the account, for which we go forward to page 1308 and paragraph 63. And by the first hole punch, there's a passage that begins, however, a key point. And perhaps I could invite your lordships to read that down to about 8 sentences, where it ends from the use of the logo. So what we see there is a finding of fact by the judge on the inquiry that in fact the use of the trademark had led to no increase in sales, no increase in margin, and therefore no additional profit. But then we see about 6 lines down, there's another sentence that says, however, all of this material which was not available to my Lord Justice Arnold has to be balanced with the conclusions reached, which we looked at earlier in the judgment. And so the judge here is in a bit of an impossible situation because he's trying to balance 2 fundamentally inconsistent findings of fact. We see him saying this in terms, if we look over the page, top of the paragraph, there's a sentence at the end of the second line which begins, in particular, it's necessary to balance the points made by Mr. Justice Arnold quoted earlier in this judgment when determining the liability issues in this case, with further evidence now available. So we say the problem the judge was addressing here was rather unique and really offers no assistance in this particular case. It's also worth pointing out while we're here.
On your argument, there should have been no award, no financial award. Is that right?
I beg your pardon, ma'am.
On your argument, there should have been no financial award in Jack Willis because there was no additional profit.
That would be correct, yes. Yeah, and what the judge here is saying in my submission is he's saying that's the correct result, but I can't reach that result because there's a finding of fact from the liability stage that says there was some advantage. So I've got 2 inconsistent findings of fact, and I'm trying to strike a fair balance between those.
Well, I wonder, are they necessarily inconsistent? There is an unfair advantage, but it produced no actual benefit.
Well, in my submission, that is what the judge is saying in the top of paragraph, or in the top of page 1309, when he says it's necessary to balance the points made by Mr. Justice Arnold with the material now available. That's the task that he's wrestling with. His findings as to what profits were caused by the use of the logo.
I mean, in effect, I think what you're saying is that what the judge did in paragraph 64 is inconsistent with his factual finding in paragraph 63.
Indeed, it is. It is.
Can you explain where the 41% in paragraph 64 comes from?
So what's happened here is that this was Mr. Bazant was the expert in this case as well. And he has analysed a trademark agreement with a third party between House of Fraser and a third party. He's analysed a profit split of 3%. And then on the facts of that case, that profit split has been adjusted down, in fact in that case, to 1.5%. And then I think what's then been done is one has looked at the actual profits that have been made. One has looked at the revenue that was generated and worked, and that's how the 3% figure was calculated. And then it's been revised down. As to how that leads directly to the 41%, it's not clear from this judgment. What is clear from this judgment is in the immediately what follows the 41%, that Mr. Gill, that's the expert from the other side, was not instructed to consider the issue. So the judge here wasn't wrestling with he didn't have the point that I have made to my lords about the inappropriate nature of using a licensing agreement at all. That wasn't an issue that he had to deal with. And Mr. Bazant's evidence wasn't contested in that case. And in this case, the position is different, and Mr. Bazant's approach on the evidence was contested, as I've shown. So I say that the facts on this case are slightly unusual, and so it doesn't offer a great deal of assistance. In any event, what it does show is that it is appropriate to adjust profit splits depending upon what is appropriate to do. We covered the evidence in this case that my Lord Justice Nugee alighted upon, that the correct uplift would be to around about 39%, taking the point. So that is my first point about the inappropriate use of the patent licensing agreement. The next point is the strength of the patent. The point here is that the judge's findings were inconsistent with the absence of an NIA. We know that Astronics couldn't have made any profit at all without infringing. And we suggest the significance of that finding ought to have operated as something of a sense check on the judge's finding that only 13% of those profits were attributable to the patent. And there's a further sense check which we point out in paragraph 117 of our skeleton, which is that the way in which the judge calculated the profits meant that the apportionment percentage was 13% if there was no NIA, 21% if there were an NIA. So the judge's method is inversely sensitive to the strength of the patent. We say that's illogical, and it ought to have operated as another cross-check, revealing that something had gone wrong. As to how we say this court should put it right, I want to come back to that question, but I need to address you first on the procedural errors in excluding Mr. Ryan's evidence. Now, for that, we need to look at the pleading, which is in the points of defence, the core bundle, tab 26, and page 393. This is Astronics pleading on apportionment, which they introduced from paragraph 21. And then the leader took you through that pleading. I'm not going to look at it again, but we can skip forward to paragraph 24 on page 402. Here, Astronics sets out its case as to the basis on which the profits should be apportioned. It says in the final sentence on that page, the basis for that apportionment is a matter for evidence. We didn't challenge that plea. And it then pleads some methods, all of which are expressly without prejudice to the generality of that plea. So their position is that the basis and the detail for apportionment is all a matter for evidence, not a matter for pleadings. We didn't challenge that approach. We also then need to look at paragraph 28b on the following page. This is under the heading differential profits / comparables, so we're no longer in the apportionment section. And the plea in 28b, which you see in the fifth line, fourth and fifth lines, the profit due to Lufthansa should be no more than the rate payable in the agreement. That rate
seems to be the wrong place.
Paragraph 28, capital B,
28. All right.
page 404. It's the final paragraph on that, at the bottom of that page. It begins, further or alternatively, the defendants will say. The final sentence, defendants will say that profit due to Lufthansa throughout the relevant period is no more than the rate payable in the agreement. So that's a plea that the profit should be capped at the rate in the agreement, which requires a comparison between the rate in the agreement and the profits. That's why this is under the heading comparables. It isn't an apportionment plea. So in response, we pleaded that this was inappropriate as a matter of law. We also denied that the 2014 teaming agreement was a suitable comparable, but we didn't plead any apportionment case because that wasn't the case that was being advanced. What we did do, separately in a Part 18 response, is say that we would argue for a high apportionment at trial for two reasons. One, we relied on the significance of the invention, and two, we relied on the relatively trite nature of the other technical aspects of the mPOWER systems. And the purpose of that pleading was to make clear that our case was non-binary. If the apportionment were to be done, we would argue for a high figure. We didn't elaborate on the detail, but the parties had agreed the basis for that detail was to come in evidence. So at the close of pleadings, the boundary lines were drawn and we were awaiting each other's cases in evidence. We got the 2014 teaming agreement apportionment case in Mr. Bazant's first report. We didn't take any objection to him doing that. Instead, we addressed it in reply, and the defendants didn't take any objection to that. They instructed Mr. Bazant to deal with it in a third report. Neither party complained about the other's approach as a matter of procedure. The dispute at trial was all about the substance of the evidence, which both accountants had addressed in their reports. Neither side raised any procedural issue. And it was the judge himself who decided to exclude Mr. Ryan's reply evidence on procedural grounds. He hadn't given any warning that he was going to do so, and he hadn't received any submissions from Lufthansa. And so critically, he wasn't aware of the history that I've just gone through. Both sides had agreed that apportionment was going to be a matter for evidence. And so we say that the judge was wrong to find that Lufthansa was guilty of any procedural wrongdoing, and it was procedurally unfair for the judge to exclude Lufthansa's evidence without having given us the opportunity to address the point.
What did he actually say about this?
He
The judge had been quite intimately concerned with the pleadings because Mr. Culligan showed us the contested application to amend, so he certainly must have had an acquaintance with the pleadings.
He did. He looked at the evidence and then he rejected it on procedural grounds. He rejected both Lufthansa's ability to argue for a higher apportionment, and he rejected Mr. Ryan's reply evidence.
Just point us to the paragraphs.
Indeed, as well. He did that. In paragraph 591 is where he rejected Mr. Ryan's
591.
591 on page 330. It starts at 590.
Yes.
So he rejects it on the basis that we hadn't pleaded a positive case. He
That
rejects it.
sentence begins with an expression of agreement with Mrs. Justice Bacon. What's he referring to there?
My Lord, if I may, I'm going to take you there in a moment. And then 591, he disallows Mr. Ryan's evidence also for the reason, 3 lines down, if Lufthansa had intended to rely on it as an alternative, he should have given evidence about it in Ryan 1, not in Ryan 2. We say he was wrong on both of those points. And so before I address both of those points, and I pick up on my Lord Justice Arnold's query, to just give you the thrust of what Mr. Ryan said. He said first, he thought that Mr. Bazant's reliance on a patent licensing agreement at all was flawed. Second, he said that if you were going to rely on a patent licensing agreement, here is the 1998 one as well, and the figure is 84%.
Figure is
84%. We say that's classic reply evidence. And so I want to turn to Astronics' points that they take against us on this. The first 3 points they take are the
just
objection.
before we go there.
Yeah.
Is this a case management decision?
No, I don't. This wasn't a case management decision because, as I say, what the judge did was choose to exclude our. I suppose it may be. What he did was choose to exclude our evidence without giving us the opportunity to argue the point. So, irrespective of whether it was a case management decision or not, it was procedurally unfair.
Right.
As to the pleading point, as I'll show you in a moment, he's misunderstood the position. So my learned friends say that we weren't, the first point they say is that we weren't entitled to advance a case because we had pleaded it in the Part 18 response rather than in the points of reply. That's their first point. We don't think that's a sensible distinction, and the reason for that you can see in paragraph 577 of the judgment on page 323. This, to answer my Lord Justice Arnold's point, is the transcript from the hearing before Mrs. Justice Bacon. And what I say at the outset, top, is that I want to be clear about our position on apportionment. I say that we're going to argue that no apportionment is appropriate, but also in between the two hole punches. I say that the judge may be perfectly entitled to take the view that neither extreme is correct, and the correct result is somewhere in the middle, 50, 60, 40, whatever the judge decides on the material. Mrs. Justice Bacon tells me that if I want to run a case that isn't 0 or 100, I need to plead that. And at this point in time, we were imminently due to provide a Part 18 response. And so if you look over the page, final part of that transcript, 4 lines from the bottom, Mrs. Justice Bacon says, I think you're going to need to clarify that. And I say we've been asked Part 18 request in that regard, we're due to respond. That's probably the appropriate place to do it. There was no procedural objection to that from the judge or from the defendants, so that's what we did. And after we did so, the defendants didn't raise any issue with the pleading, neither of its form nor of its substance. So the objection the judge takes...
Could you just show us the Part 18 response briefly?
Yes, I can probably pick that up from my learned friend's skeleton at 129. which is in core bundle, tab 4, page 98. And they reproduce the full Part 18 response there, so far as the court decides.
Do you in the pleading say that using the license agreement is wrong in principle?
No, we don't, because at this point that case hasn't been pleaded against us. So we, and of course our case is that using licensing agreements isn't the right approach at all. So we didn't introduce that case ourselves. That was a case we introduced in response to Mr. Bazant's evidence. So at this point in time, in Part 18, when the Part 18 response was made, we hadn't seen Mr. Bazant's evidence. As I say, the pleading doesn't go into much detail, but the parties have agreed that that was all due to come. So I say the objection they take as to the form of the pleading is opportunistic and retrospective. They also take a second point. They say the pleading is hopelessly vague. But my point there is that the detail was due to come in the evidence. That was the agreed position between the parties. I also say that the pleading is quite clear. We're relying on the strength of the patent relative to the other factors in the Empire system. And their third point is that they say that the pleading is unsustainable in the light of the judge's findings. We don't accept that criticism because the judge found that without the patent, Astronics wouldn't have made any of the profits in issue. And so we say that finding supports, in fact, the pleading as to the strength of the patent.
Can you help me on this? I mean, I'm not sure if this is a point respondents are making or not, but may underlie some of what they say, which is that what we have seen, I think, is that in respondents' pleadings there was at any rate reliance upon the 2014 teaming agreement as a compromise. Now one can debate what that means, but at any rate it's identified as, to use an expression you've used in another context, a data point. By contrast, when we look at your pleadings, we see no reference to the 1998 teaming agreement as a data point in any context whatsoever, so far as is relevant here. What would you say to that?
The reference in Astronics' pleading to the 2014 teaming agreement wasn't a data point for the purposes of apportionment. It was expressly under a different heading, comparables. And we said the comparable case was not appropriate as a matter of law. So we weren't running a contrary case that instead you could use the 1998 teaming agreement as a comparable. And we weren't addressing a case, the 2014 agreement was a data point in an apportionment exercise. When it came in Mr. Bazant's report, that's when we replied to it. So the points that are taken against us on, on the evidence are in my learned friend Skeleton at paragraph 131. There are 4 bullet points, and there's a first point taken in the paragraph at the top. First, they say in the paragraph at the top, they say Lufthansa didn't rely on the evidence of Mr. Ryan at trial. We did. We referred to it in our closing submissions. For your note, that's in the confidential bundle at tab 13, page 526. We don't need to go there. Second point in sub-Roman 1 is the point about where the pleading is, and I dealt with that. And the third point, sub-Roman 2, is that the evidence went beyond reply. We disagree for the reasons I've explained. Fourth point, sub-Roman 3. They say that Mr. Ryan should have given the evidence on it in his first report. But as I say, at that point, we didn't have the case presented to us by Mr. Bezant for him to respond to. And their fifth point, in sub-Roman 4, is that the evidence wasn't in the joint statement. Now, that's correct so far as it goes, but the evidence was in his second report, he attested to it at trial, and he was cross-examined on it. So all of those reasons, which are alternative reasons for disallowing his evidence, fall flat. My learned friends then, in paragraph 134, they say, well, alternatively, if the judge were to allow his evidence, then the judge could have found that it wasn't a more relevant benchmark than the 2014 agreement. And a finding that one is more relevant than the other, we say, wouldn't lead to necessarily excluding the less relevant one. It all becomes a matter of weight. It wasn't, we don't suggest that the judge should have picked one over the other. It's all a question of balancing the various different data points. That leads me to my final point, which is what should now be done about it. The exercise is inherently broad brush in nature. One often talks about the broad axe, and I'm afraid that this is a case in which we're respectfully saying that that can be wielded. To assist you in doing so, I make the following points. First, we have Mr. Bezant's apportionment analysis at 13%. We know that's too low, far too low, we say. Correct uplift on that would be to 26 to 52%. Second, there's the evidence of both Mr. Ryan and Mr. Bezant that licensing splits of 50% are warranted for good patents, which are highly material to commercial success. Lufthansa's patent, we say, is one of those. But even 50% as a licensing split would be too low. It would still need to be uplifted to take the infringing profits away from the infringer. So the correct figure, we say, should be somewhere north of 50%.
North of?
50%. Third, there is the 1998 teaming agreement. Mr. Ryan's evidence was that that led to a figure of 84%. It was common ground that that figure was on the high side. But as I've said, the correct figure is north of 50. And I should point out here that in my learned friend's skeleton, in support of their appeal on KID apportionment, they suggest that an appropriate licensing split based on the 1998 agreement is an allocation of 50% of the profits to Lufthansa. Again, that would require an upward adjustment. And fourth, finally, there's the figure in Germany where the German court awarded 50% of Astronics profits. It did so in circumstances where Claim 1 was held invalid, Claim 2 was valid and infringed. The scope of protection of Claim 2 was much narrower, and so Astronics were able to devise a modified product which did not use that invention. They manufactured that product and they sold it. It still used the invention in Claim 1, which is why they couldn't rely on that product here. But in Germany, they had and used a non-infringing alternative. So the German 50% award, we say, should be higher in circumstances where there is no non-infringing alternative available. So we say, with all of that, the correct figure is probably going to be somewhere between 50% and 84%. And if you go between those two, you get to about 2/3. But as I say, it's a very broad brush exercise. Lords, unless I can help you further on this issue.
Thank you very much. Right, where do we go next? Mr. Purvis.
I think it's me. Can I just Just give me a moment to put my files in the right order. My lords, my structure of what I'm proposing to do is to give you a very quick nutshell account of what we say we ought to do.
So you'll need to speak up a bit. Nutshell account of?
Of what our position is on this appeal. Then to give you some remarks about the law, the established authorities on accounts of profits and apportionment in intellectual property cases, both in this country and in the Commonwealth, in particular in Canada. Some cases that my learned friend Mr. Cuddigan didn't take you to are only in passing, but some passages in those cases that you may not have seen. And on that basis, to then make submissions as to the state of the law, as we understand it, on the question of apportionment in intellectual property accounts of profits cases. Then to have a quick look at some of the relevant findings by the judge on the facts of the case that informed its overall decision. And with all that in mind, then to look at the grounds of appeal and what my learned friend said about those yesterday and this morning. Sorry, my learned friends said about those yesterday and this morning. In summary, our submission is that this judge gave careful consideration to all the arguments, both legal and factual, as to whether this was an appropriate case for apportioning profits. And his judgment on that issue was a matter of evaluation of a large amount of evidence, as you could see from the sheer volume of the judgment, on which he made a series of important findings. And I'm going to show you some of those findings, but of course it's impossible by definition to go through all the matters the judge took into account. One always has in mind my Lord Justice Lewison's famous reference to islands in an ocean of evidence being all that Court of Appeal can seriously hope to have in mind. In the light of his findings on the evidence and the established law, we will submit that his decision to apportion the profits in the way he did was a conventional one, and hardly a surprising one in a case where the invention was only one safety element within a complex product, namely the mPower fusion system held to infringe, which incorporated many components and overcame many safety issues which had nothing to do with the invention at all. Indeed, in most cases, representing the bulk of the profits claimed and awarded in this case, the product, that is to say the mPower fusion, was sold to ultimate consumers, that is to say the airlines, as part of an even more complex product, the in-flight entertainment system of Panasonic, where the judge held there were yet many other important drivers of the sales and the profits over and above any particular feature of the power supply units incorporated within it. That left the question of the proportion of the profits that should be attributed to the invention. The judge was provided with no positive case pleaded by Lufthansa as to how the apportionment should be carried out, nor even the proportion of profits that should be allocated to them as patentee, but was provided with coherent evidence in support of the defendant's pleading as to a number of possible methods to use, with calculations of the results of those methods carefully considered and ultimately applied, one of them. And we say, in the end, that is a conventional approach for which he can't legitimately be criticised. Coming to the law on accounts of profits and apportionment in IP cases, as your lordships will be aware, an account of profits is available as a remedy in the United Kingdom for breach of any intellectual property right. It is an equitable remedy which one would expect and is indeed applied on equitable principles. The proper approach to the remedy has been developed and explained in numerous United Kingdom authorities and has, we submit, been reasonably consistently applied in those authorities in terms of the principles behind it and the way in which those principles are implemented. And I want to elucidate some of the underlying principles by reference to the authorities. And the first of these is that the courts in the United Kingdom have consistently rejected the argument that one awards all the profits of the infringing business or all the profits of the infringing products or processes, as opposed to considering the portion of those profits properly attributable to the subject matter of the intellectual property right. And it is by that means that they strive to avoid the situation in which the patentee receives a huge and inequitable windfall from efforts of the defendant which are unrelated to the particular contribution which the rights holder has made. And the clearest early exposition of this, which goes through the bulk of the cases which have been decided prior to 1983, including the patent cases to the same effect, is that of Mr. Justice Slade in My Kind of Town against Seoul, the Chicago pizza pie passing off case, which is in your authorities bundle 1 at tab 22. This is of interest because the point itself was squarely raised as a matter of law by counsel Mr. Prescott, and had to be squarely addressed by the judge as to the terms of the account. And the judgment on the merits ends at page 446, and the judgment on this point of principle begins and goes through from there all the way through probably to 457. Before Mr. Justice Slade, the point of law was whether an account of profits for infringement of an intellectual property right, here passing off, was for all the profits arising from the acts which were unlawful and had therefore been restrained by injunction, that is to say, the operation of the restaurant under the offending name for a period of 18 months, or only a portion of those profits which properly reflected the value of the right in question. And he ultimately held the profits awarded shouldn't be wider than what could be regarded as equitable and in accordance with the interests of justice. And he summarised it perhaps best in the passage which is at page 4. Well, it starts at the bottom of 455. Where he sets out, having considered all the relevant authorities, the order which ought to be made in relation to the account. So that's from lines 35 onwards. And he says, an account in this form will, in my judgment, accord with the principles established by cases such as Cartier and Carlyle and Legal and Goodwin, and will operate to give the plaintiffs that part of the defendant's profits attributable to the defendant's wrongful acts, no more than less. And he goes on, the evidence before me indicated that the defendant's restaurants are thriving concern. A considerable part of their profits owes nothing to the plaintiffs or the plaintiff's reputation. To order an account in the form sought by the plaintiffs would be tantamount to a decision. Mr. Soul and Mr. Yeager, whose personal honesty is not in dispute, should be treated as having conducted the whole of the business of the defendant's restaurant throughout the relevant period as trustees for the benefit of the plaintiffs, albeit at a reasonable wage for themselves. The reference to the reasonable wage, I think, is that it was conceded that even if all the profits were to be handed over from the business, there would be something equivalent to an equitable allowance for the directors' efforts in having made those profits. A concession of the kind, which is of course not made in the present case. In my judgment, any such order on the facts of this case would be quite inequitable, though the defendant's use of the name was, in my judgment, unjustifiable and correspondingly had to be restrained by injunction. No other features of their activities, in my opinion, by themselves constituted wrongs against the plaintiffs, of which plaintiffs could complain in law. And then he says, we'll come back to this, on the particular facts of some passing off cases, it may be right for the court to regard the whole of the defendant's business as a parasitical enterprise which has fed itself entirely off the plaintiff's goodwill, and the present case is not one of those cases. He then suggests how the profits made through the name may be isolated on the actual taking of the account, and notes from line 30 that that's going to be a task which is far from easy. And if one then looks from the bottom of 456, having referred to the onus of proof, he says proof of such matters on a mathematically exact basis would clearly be impossible either way. The master should approach the matter broadly from the following standpoint. Entitled to an account of profits, but claiming the whole of the profits, subject only to the allowance, made a claim much wider. The general intention of the court in making the order which it has been made is to achieve a fair apportionment so that neither party will have what justly belongs to the other. What will be required on the inquiry will not be mathematical exactness, but only a reasonable approximation. So it is a matter of justice and equity.
So what the order says
Yes,
You can see that on page 455 of the bundle.
yes,
The master is to assess the profits which are properly attributable to the use by the defendants of the name.
yes,
Mr. Justice Slade then contemplates that what he will do is to compare the profits actually made and the profits which would have been made if the name hadn't been used. And that's pretty close to what Mr. Cuddigan has called the differential profits test. But then on page 457, after Mr. Prescott asks for some clarification,
yes,
he says, just line 34, be a matter for the master to decide, employing common sense, whether particular profits are or are not properly attributable. And then he says he doesn't really feel able to tie the master's hands by any more definite statement than that.
yes. And he said 455, if you may recall, lines 14 to 18.
Yeah.
What he has about clearly profits made by the sale of meals to customers who are not confused by the name are not attributable to the use. So what he's doing, and I'll come back to this, we submit, is differentiating the true substance of the intellectual property, that is to say, the valuable goodwill which is being protected, from the nature of the defined illegality, if I can put it that way. What Mr. Prescott was arguing was, well, we get an injunction against the business trading under the name. You've traded under the name, that was all illegal, and therefore all the money you made was in the course of your illegal activity. And what the judge is saying is that's not the right approach. The mere fact that the activities from which the profits were made were illegal, it's not the issue. The question is what profits can properly be said to have been drawn from the true subject matter of the right. Here, the right not to be misrepresented, or the goodwill that brings in business, etc. And we will submit, and I'll show you some other cases, that is the consistent approach of the courts. They do not look at the substance, the mere reality of what's protected or monopolised. They look at the underlying substance of the contribution of the right holder and seek to isolate the profits attributable to that. Substance, not form, as Mr. Justice Laddie put it in Celanese.
Well, that comes from Lubrizol, I think.
Sorry, maybe Lubrizol. And it's notable that in that judgment he refers to the decision. Sorry, what time is it? Yeah, sorry, I was away, but I should show you this. It refers to the, amongst the number of authorities, to the to the United Horseshoe and Nail decision, and that's between 453 and 454. Which was referred to by Mr. Hicks on behalf of the defendant. The principles established that when a patentee elects to claim the profits from the unauthorised use of the machinery, the profit from the use of the invention must be taken into account, not necessarily that from all the infringing sales. Lord Watson said it would be unreasonable to give the patentee profits which are not earned by the use of his invention. So again, the distinction between the pure act of infringement and the invention itself. But I'll come back to that in the context of patents. Similar approach given by Mr. Justice Briggs in Cipriani, which you have recently looked at, I think. That is Joint Authorities 2, tab 37, paragraph 8. Where he sets out very pithily the law, including the no answer to say that similar profits could have been made in an uninfringing way, but I'll come back to that point. But importantly, fourthly, he says towards the end of paragraph 8, where a single head of profit is attributable to a number of causes, some of them infringing, some not, it's necessary and appropriate for the court to conduct an apportionment to work out on a broad brush basis what proportion of profit was due to the act of infringement. And the result of many of these authorities, Celanese, My Kind of Town, Cipriani, Jack Wills, is the award on an account of considerably less than the factual profits made by the infringing business or the infringing product or the infringing process. And we submit there are two main reasons for that. And the first, which is relevant to many of my learned friends' submissions, is that the infringing act is often defined in terms which include far more within the scope of the act than the actual underlying contribution of the right holder. So if one starts with trademark cases, for instance, the infringing act, classically, is an act of sale of an article bearing a sign which infringes the trademark, or the provision of a service under the mark. That is how the act of infringement is defined in the act. But of course, the article or the service may have an inherent value of its own, which owes absolutely nothing to the trademark. That doesn't matter from the point of view of trademark law at its substantive level, what can be prohibited. The whole branded article is an infringement, and the sale of the whole branded article can therefore be prohibited by injunction. And if one literally set out to award the profits factually caused by the infringing act, let's say, in an extreme case, a branded diamond which had been profitably sold in a market where diamonds were suddenly much in demand. The logic would be that one would award all the profits on the sale. Those are easy enough to establish. But what the courts rightly say, as a matter of equity or legal causation, however one looks at it, is that we need to step in to ensure that the profits which are being paid to the rights holder properly reflect the actual contribution of the underlying intellectual property right. Here, the monopoly in the use of the trademark, as opposed to the article itself. That's why in Cipriani and Jack Wills, leaving aside the detail of what the courts were doing in terms of numbers for present purposes, the courts were concerned to isolate, by the methods they chose to use, the contribution of the trademark to the profits, as opposed to reflecting merely the profits on the infringement itself. And again, we say that substance, not form. My Lord Justice Lewison in Abbott, in the passage we've come to, talks about the importance of having in mind the purpose of the cause of action. And the purpose of a trademark is to protect and reward the power and value of a trademark, not the value of the goods or services to which it's attached. So when considering legal causation, the court is seeking to establish the profits attributable to the substance behind the monopoly or the right, which is the use of the trademark itself. Same goes for passing off. As we've seen, My Kind of Town, the operation of a restaurant under a confusing name is the act of passing off. So it includes the operation of the restaurant, as well as placing the name on the restaurant. The profits from the business under the name are easy to establish, but that's the form, not the substance. And the substance of a passing off case is the value of the goodwill on which the claim is based, and that's what Justice Slade in our submission was seeking to explain when giving guidance, as he effectively was, to the poor master who was going to have to carry out the count. So if only 5% of people were bringing their business to the defendant in My Kind of Town because it said Chicago pizza pie, and they were confused, thought it was something to do with the claimant, the misrepresentation has been responsible for profits caused by the presence of those 5% of people, but not by the rest, even though everybody came in to the business under the name. They all went through the door with the name above it. So far as patents is concerned, exactly the same thing applies. The contribution for which the monopoly of a patent is granted is the invention, sometimes called the inventive concept. And the purpose of patent law is to reward and protect the making of the invention and its disclosure in the patent. But, as with other IP rights, the infringing act may be defined quite widely in terms of the claim by comparison with what may be a limited inventive concept. The monopoly is defined by the claim, but that has to set out the inventive concept, but it can do it in a very broad context. And for this purpose, I could show you, if I may, the remarks of my Lord Justice Lewison in Abbott at paragraph 8. J4. So that's, yeah, authorities bundle 4 at tab 47.
Tab 2, sorry, volume 2, tab 47.
Ah. Sorry, bundle 2, tab 47. And maybe worth just to put this in context, starting at paragraph 3 of 1275. So this case was all about a patent for display panels used in shops, but the invention related to particular inserts for the slots to enable them to be fitted into the walls. And it says as it says in paragraph 6 of the summary from Mr. Justice Burse towards the bottom of 1275, it became standard practice to provide inserts for slots as a protection against damage and to hide the machine's surfaces. The accessories are then fitted into the inserts rather than being fitted directly into bare slots. Inserts made by extrusion, and then there's a reference to the standard inserts in paragraph 7. And over the page, problem with slide-in inserts, if the edge of the slat wall wasn't accessible, for example, the corner, there's no room to slide it into place. Snap-in inserts solve the problem by being inserted from the front with a spring action, because they need to be compressible. They're made of PVC instead of aluminium. The invention in this case is a snap-in insert made from a resilient metal like aluminium. And if one looks at the claim, of course, it isn't just a claim to snap-in insert. The wording of the claim is a display panel having various characteristics, all of which one can assume were old because of the way the claim is structured. And then towards the middle, characterized in that the insert is made of a resilient metal. And it's from that point on that one finds the actual inventive concept behind the patent. It's only relates to the insert. It's made of resilient metal, then it has these particular shaping characteristics. And if I can then take you to paragraph 7, your Lordship sets out the underlying basis of an account of profits in a patent case. Purpose not being to punish but to prevent unjust enrichment. Underlying theory, treated as having carried on his business to the extent it infringes on behalf of the patentee. That's taken from 7 means. The broad principle is that the patentee is entitled to profits that have been earned by the use of his invention. Patentee doesn't recover those profits, infringer would have been unjustly enriched. Quantify the extent the infringer would be unjustly enriched if he were to retain the profits. That requires first identifying the patentee's invention, and second to decide what profits the infringer derived from the use of that invention. Second of those questions may give rise to difficulties in relation to convoy goods. The court must determine what profit has been earned in a legal sense by the infringer's wrongful acts, obviously with the principles of preventing unjust enrichment as previously set out being borne in mind. It is clear then that the account of profits looks at the facts through the lens of what the infringer has done and what bounty suffered by way of loss is irrelevant. And then in paragraph 8, the first question requires the identification of the invention. It's common ground for the purpose of assessing damages from accounts of profits the scope of the invention is not necessarily coterminous with the scope of claims. And Ms. Justice Laddie explains the reasons for this in Celanese, and that's the famous passage in Celanese about whistle on a battleship, pointing out that the claims of a patent may not simply limit themselves to the inventive concept itself, here a tin whistle, but we'll start with a phrase such as a battleship comprising or incorporating or including a whistle with the following characteristics. And the reason one has to identify the inventive concept as opposed to simply focusing in on the infringing act is that you would otherwise end up with utterly unjust enrichment of the patentee, here in this case getting the profits on the battleship, or in the rather more limited case of Abbott, getting all the profits on what was claimed, which was, as we saw in paragraph 4, the display panels, including the little bit that was actually the invention. And that's why in our submission, my lord, in paragraph 9, refers to the judge's consideration of the inventive concept and quotes the description of the invention there as the composite idea of an insert made of resilient metal with a particular shape and interacting with the slot in a particular way. So, rather a lengthy explanation to get to the proposition that one is not simply asking what profits have you made from the infringing product. One is asking what profits have you made from the underlying subject matter of the right, here the inventive concept or inventive core of what has been claimed. And in Abbott itself, that is why my lord made the distinction when it came to the recovery of profits between sales which were driven by the inventive concept itself, that is to say, where customers only bought the product because they wanted the insert, a bit like the customers in my kind of town who went into the restaurant because they were confused, and other sales not driven by that concept. And in the case of those other sales, my lord directed sending it back to the trial judge that profits needed to be shared between the parties in accordance with the value of the contribution of the inventive concept. And that is the basis of the second judgment, which is in the bundles, in which both those were carried out. As Honour Judge Haycon found the proportion of sales which were driven by the inventive concept, and in relation to the other sales, because these were of course all sales of panels, allocated a percentage of the profits to the infringing bit. How does that? How can we illustrate that by reference to the present case? You've looked at the claims of the patent here in the supplementary bundle at tab 6. I don't know whether it's worth.
Well, I think we looked at the claim as quoted by the judge, in fact. But
Right, yes, I think it is. And the claim it is, and the claim is to a voltage supply apparatus which has certain characterizing features. But of course, no contribution has been made by the patentee to the supply of voltage as such, nor indeed to the numerous other components which go into the ability to supply voltage to an aircraft cabin and owe nothing to the invention, which, as I shall show you in the present case, were multifarious and complex. The contribution made by the patentee is to a single aspect of the supply of that voltage, which is a particular safety device. If your lordships look at the...
We've got the claim at page
Judge.
72 of the judgment, if that's
Yes,
what you want
thank
us to
you.
look at. It's a plug detector which detects the presence of two contact pins, and the supply only supplies the voltage. The presence of two contact pins is detected simultaneously.
That's right. So, as in many cases, this is a claim with a pre-characterizing and a characterizing portion. And one finds the invention after the words characterized in that. So we have this broad context in which the inventive concept is implemented, set out at the beginning, which is the whole voltage supply apparatus, and then the specific inventive core. And the point that Mr. Justice Laddie was making, of course, on the battleship analogy, is that there's literally nothing to stop a patentee framing his pre-characterizing portion in whatever broad terms he wishes. He could have said an aircraft with a voltage supply apparatus, etc., or a ship set of seats for an aircraft with the voltage supply apparatus and so forth. It's entirely random and unconnected with the actual inventive contribution that the patentee has made, and therefore, by definition, not something which the courts should, as a matter of equity, be taking into account when it comes to the award of profits to reflect the invasion of the patentee's technical contribution. When looked at another way, the patentee here could equally have simply said a plug detector and just pleaded it out as the characterizing section. But clearly that ought to make no difference at all to the profits which are recoverable on an
Sorry,
account.
what are you saying? That the reference to the plug detector could have been in the pre-characterizing section? Is that the point you're making?
Or you don't need the pre-characterizing section. You can just define the invention
Oh, I see.
as a plug detector with working in this particular way.
Yeah.
I mean, I'm not going to try and redraft the claim accordingly, but as a matter of principle, that's clearly
The
correct.
essence seems to be you don't get any supply of electricity unless the plug detector detects two contact pins simultaneously. That's the
That's
basic
the
point.
invention, and it's described in a long-winded and compendious way, but that's what it really comes down to. And one can see it if we like. If one looks at the schematic of what was found to infringe. It's at paragraph 154 of the judgment, page 87. So that's the detectors, and the context of those is in the diagram on the left-hand side, where you can see them in the middle box. And obviously you need some form of micro switch and electronics to switch on the power, to detect the fact that that contact has been made, and then to switch on the power accordingly. But other than that, that's the limit of the components which implement the inventive concept. But of course, the point in this case is that the voltage supply system, which incorporated the invention, is extremely complex, expensive, and includes all kinds of physical and electronic components which have nothing to do with the invention and contribute to its commercial value and therefore the profit we can make. The mPower system, which we can briefly look at in a minute, in the PPD, existed and worked without the presence of the invention. It was freestanding a piece of kit which worked perfectly well, subject to this safety device. The vast majority of the systems known as mPower included not only the seat unit itself, but general power management and control systems known as MCUs or AMCUs in the PPD and in the judgment. The profits of all of which are part of the pot of profits at issue in the case. We can see one's got the, we've got the confidential appeals bundle at C7. I'm not going to go to this in an enormous amount of detail, but you will see.
This is a PPD of your product, is it?
Yes.
Yeah.
So C7, page 433 onwards, one can probably start with. So there were, well actually if you look at 429, you see system overview, and you will see there were two types of systems, some with the master control, some without. Sometimes a secondary power distribution box or a remote power distribution unit, roughly the same functionality of the master control unit. And the description really begins at 433 with the advanced master control unit. So that's what is receiving, as it says in the third line, the three-phase power from the aircraft and distributing it to all the power consumers within the system, receiving commands from the interfaces that control the power consumers. These may include the ISPS within which the invention is implemented, amongst many, many other things. SPM, SPB, ditto, reading light controllers, and all sorts of other things, including IFE equipment. The AMCU not included in category 2 systems, but certainly bulk of the profits here were systems including AMCUs. And then we have the block diagram I won't take you to, which is a complex electronics. The functions are all set out in 434 again. I won't read all that out, but one can see there's an awful lot going on here in terms of power distribution, circuit breakers, ground fault interruption, configurable controls, built-in test functionality, EMI filtering, etc. And over the page, it sets out 7 different operating modes and so on. And then from 18, we probably don't need to worry about the enhanced unit. Master control unit, similar. One looks at the functionality on 437. That's an alternative system. And then 438, we get to the SPM, SPB, and the ISPS, which are similar in their functionality. And these are the individual seat power supply systems in which we will ultimately find the invention being implemented, but they themselves have a vast amount of functionality which one can see from paragraph 25, and then detailed from page 441. Again, I haven't got time to go through all these, but it's set out in sections: over and under voltage monitoring, overcurrent limiting and short circuit protection, over at 443, galvanic isolation, ground fault protection, 444, thermal sensing and control. It goes on. And only when one gets to 447, under the outlet units, shown there by reference to the nice picture of the unit itself, does one find the invention, which effectively is the implementation of what's set out in paragraph 62A and D, the power not present unless both pins are detected within 300 milliseconds. Both contacts remain active. So obviously then there are cabling and all the rest of it, which the cabling I guess has dual function, and that it also is necessary as part of the invention. So we're looking at, when one talks about, glibly sometimes, about complex products or invention used in the context of complex products, that is definitely this case, as the judge properly understood. There was a huge amount going on here, a huge amount of effort and skill inevitably engaged in by the defendants in building, manufacturing and marketing products within which the invention was implemented, but did not require the invention for their existence as such. Now we'll come to the question of regulatory limitation and the need for this particular safety function. But in terms of the technical functionality, which was there and was clearly necessary to get these products successful and on the market, it went way beyond the invention. And it's a very good example, we submit, of the importance of the principle which Your Lordship was explaining in Abbott, of making sure that one's not straying beyond the inventive concept and awarding profits associated with other things entirely. So, as I say, we say it's pretty clear that Your Lordship was making that distinction in Abbott. As it happens, the same thing appears to be will understood under the law of Canada as well. This is a convenient time to take you to that. In the authorities bundle tab, authorities
The Canadian cases all
tab 57.
Bundle 4.
Is this 4 or 3? Sorry, mine don't have numbers on, it's confusing. I think it's 3, tab 57. I was going to show you the Nova and Dow decision. So I got the bad reference. I have got a bad reference.
I thought all the Canadian,
That
all the Canadian cases were in volume 4.
Ah,
Nova and Dow is tab 89.
tab
volume
89. Why have it down to tab
4. So
57?
we've got the Federal Court and the Supreme Court.
It's the Supreme Court that I want, which is in fact tab
Tab
90.
90.
I'm going to show you on this the judgment of Justice Rowe for the majority. And one can look, paragraph 57 on 3006. He's referring to isolating the profits causally attributable to the invention from profits attributable to non-inventive features of the infringing product. And as your lordship pointed out earlier, that's a reference back to Lubrizol to allow Lubrizol to take profits which Imperial succeeds in showing solely attributable to some non-infringing feature would be to judicially sanction Lubrizol's unjust enrichment at Imperial's expense. And then at 67,
Well, at 58, he says the non-infringing option is a product that helps the court isolate the profit.
yes, exactly. I'm going to come, I was going to come back to that, but we can look at that now. When it comes to non-infringing alternatives, that is, according to the Canadian courts, at least the majority of the Supreme Court, it is a tool to assist in the ultimate job that the court is doing, which is to
And the ultimate
distinguish.
job is what he's described at 46.
Yes. Yes. Bearing in mind what the submissions I've been making about the difference between the invention and the infringing article. And this was the distinction, in fact, between the majority and the minority, I think, in Nova and Dow, at least one of the distinctions. They took different views on this point. So I was just going to fill this out by reference to paragraph 67. Again, talking about the non-infringing alternatives, but it's the same point, 4 lines down at 67. Sufficient evidence satisfied that profits from the infringing product arose by virtue of features other than the invention. And then 69 and 70, I think a point that's already been made, I think by my Lord Justice Lewison. There was an important finding by the reference judge in Nova and Dow of what we would call, I think, driving the sale, that the customers were only buying Nova's plastics because they contained the features captured by the patent. They sold the unique patented thin and durable plastics. So it was the essence of the product, we'll come on to that proposition, and driving the sale. And then second, no infringing options that would help the court isolate the profits causally attributable to the invention from profits attributable to non-inventive features of the infringing product. And that, we submit, is an important passage with which the minority took issue, but the majority of the Supreme Court, rightly in our submission, held that that was the job of the court when carrying out an account of profits for infringement of a patent. So that's the first reason for cutting down the profits from merely the profits on the infringing article. The second reason, and it perhaps is related, but adds other factors, is that there may be multiple effective causes behind the making of a profit from the sale of the infringing article, many of which may be the results of inputs by the defendant for which the claimant has no responsibility, which are unrelated to the invention. There are all sorts of different examples of instances in which such causes can be seen to compete with the invention, if one likes, for responsibility for the profits. A defendant may have had to make huge and innovative efforts to create or open up a market which previously did not exist. They may have overcome technical products to make the product marketable, perhaps in a particular context, and we'll come to the facts of this case in relation to that, which the claimant or its licensees had been unable themselves to solve, and therefore may have accessed markets through their own independent efforts, which were not available simply by using the invention. Of course, a product may be covered by multiple patents owned by different people, of which the invention was only one. Clearly, there are serious difficulties in a case of that nature in saying, well, it's an infringing article, therefore give me all the profits, because there are multiple parallel causes of equal strength behind the profit. There may be cases where purchasers care nothing about whether the invention is actually used, but do care about the level of service provided by the defendant. And as a matter of policy, for the claimant to scoop all the profits that have been created by these independent causes in any or all of those circumstances would be unjustly to enrich the patentee and would unfairly deprive the defendant of profits from matters which were not connected to the use of the invention. I mean, that goes back to cases like Cotton and York Close, in which there was a copyright infringement of a house design infringed by the building of the house, which then, of course, created a profit in the hands of the developer. The plaintiff was held not to be able to recover profits attributable to the marketing, advertising and selling of the houses, as opposed merely to the building, nor profits attributable to things within the house that have nothing to do with the design of the building either, such as the installation of the kitchen. That's a case that's summarised in Celanese and passages that
Mm.
you've been taken to in the skeleton. There would be no obvious purpose, we submit, to permitting a claim to profits which went that far, unless, as Mr. Justice Slade said, the whole purpose was to seek to punish infringers, but we know that is not the law. Infringement can take place in good faith. It's an offence of strict liability, and it is simply a matter of disgorgement of what the court considers to be the benefits of using the intellectual property right applied equitably. We have added this point in our skeleton by way of a parallel illustration. This kind of problem is not unique to intellectual property cases, although the factors that are characteristic of those cases, even in cases where a much stricter approach to accounting for profits has generally been taken, that is to say, profits made by a trustee from trust property. And of course, as Mr. Justice Slade said, this is not what's going on in an IP infringement case. The courts still seek to separate out, to at least some degree, the profits made by the use of the trust property from the independent inputs of the trustees in enabling the profit to be made. And that's what's known as the equitable allowance. We refer to that in paragraph 21 of our skeleton argument by reference to the Ricadzi case, in which, of course, despite the fact that this was a strict liability for breach of trust, the ultimate profits that were made from the activities that were held to be in breach of trust were split by the trial judge. The Court of Appeal approved it, and the Supreme Court didn't interfere, was split 75-25% to reflect the input of the trustees in making the profits. We submit it would be fairly remarkable if intellectual property law took a more drastic view of what had to be disgorged than the law trust, particularly in the light of the comment of Mr. Justice Slade. Having said all that, of course, there are cases in which it has been held that apportionment was not necessary, and one can run through those cases reasonably quickly. These are cases where the product or business is no more than a mechanism for the exploitation of the intellectual property right in question. Perhaps a canvas on which the intellectual property right is painted. They're generally simple cases. One could imagine the sale of fake works of art, for example, knockoff football shirts, or simple mechanical products, let's say a widget, which can properly be said to be no more than embodiments of the inventive contribution. The beakers in Dart and Deco were examples of that. A good example is the one that's often cited, the bras in Peter Pan and Silhouette, the whole of which was said to have been made by use of the confidential information. So this was a case where under a license agreement originally, an entire scheme, set of blueprints, instructions for manufacture, enabling the manufacturer to produce the whole bra had been handed over. So the confidential information was, by definition, the entire product. And it was held to have saved, I forget how many months of development time, or it was accepted to have saved all that development time. All you had to do was plug in the information, the bra was produced. It was a rare case of a complete coincidence of the protected right. Here, confidential information with the product itself. And Ms. Justice Slade, as we've seen, put it in the passage we've looked at as a case in which the court could regard the whole of the defendant's business as a parasitical enterprise which has fed itself entirely off the plaintiff's goodwill. Other phraseology has been used. My Lord Justice Lewison in Abbott, paragraphs 36 and 37, referred to these kind of cases as where the infringement is the essential ingredient in the creation of the defendant's whole product. In Dart, the phrase used was, this is, you can take this from Abbott actually, paragraph 23, quoting Dart, where the infringement was the essential feature of a single item. And borrowing from Metropolitan Meters, the phrase, the very essence of the infringing product, has also been used there, where the infringement was the mechanism for the control of the gas supply, which was the whole purpose of the meter. I'll give you some more references to Peter Pan.
Or would you like to do that at 2 o'clock?
The short adjournment. Thank you.
2 o'clock.
Court rises evening.